Hello and welcome to Big Ideas. Our guest for today is Vikas Mahendra. He's the co-founder of Court, an online dispute resolution platform that makes dispute resolution more accessible and less expensive for the litigants. We will discuss on how can we draft contracts in such a way that dispute resolution becomes more accessible to all types of litigants. There is no perfect contract, so disputes are inevitable when it comes to contract between two parties. However, we see that when organizations draft contracts, it's usually templatized form and ranging from simple to the most complex disputes all go through the same resolution process. So in your experience, whether it comes to your experience at Cord or as a practitioner yourself, what are the ramifications of such standardized form of contracts when it comes to the dispute resolution clause? And how does it prevent the codes from being more accessible for the litigants?
Yeah. Thank you, Pastor, for having me. It's a problem that's very close to my heart. I'm an arbitration lawyer, Secretary Arbitration Board of India. But in that role, one of the things that I really want to achieve is arbitration has typically been for these ultra high value disputes. In fact, even when we were in college as lawyers, when you had that course on ADR, right, you would have mediation where you're talking about family disputes, smaller disputes, conciliation similarly. And suddenly you go to arbitration and you start talking about international arbitration, which for me was a dissonance because alternate dispute resolution is an alternative to make it more accessible to the parties. And why is it that that accessibility was restricted to only the biggest companies was a concern that bothered me for the longest time. So we started looking at how to change that. And we need to understand why the need for changes and go to the question that you were asking in that context. Anytime a commercial party drafts a contract, they are planning to address the most complicated dispute that can arise out of that contract. And that is also legitimate because, you don't want to be in a situation where uh, if and when that really complicated dispute arises, your dispute resolution clause is incapable of dealing with that. So I understand that. But the reality is things go horribly wrong only very well. It is more common to have disputes which are significantly simpler, significantly smaller. But then you're stuck with that contract which is looking at a dispute resolution clause which is catered only to the most complex high value disputes. And that meant that a lot of times commercial parties would not even go into arbitration, even though the arbitration clause was there because it was simply inaccessible. I'll give an example, anecdotally. Uh, I had a client of mine as part of my arbitration practice who came to us in a shareholder dispute. He was a promoter of a company, a relatively small stake after all with the VC funding had come in. And the company itself was valued at about 700 crore. They had an SIEC arbitration 3-member tribunal. And that was a dispute resolution clause in the shareholders agreement. So when this gentleman wanted to sue his other promoters over a particular dispute, he still had to go to SIAC for the 3-member tribunals to be constituted, even though the value of his dispute was nowhere close to 700 crores. In fact, it was closer to sort of 1-2 crore mark. And yet, that was a dispute resolution clause. So he initiated a dispute. The SIAC very promptly sent him an email saying, for this dispute, you will have to deposit a few tens of lakhs as an advance on cost and expect the cost of dispute resolution to be close to about 1-2 crores, which is pointless. His claim was 1-2 crores. So eventually he decided not to pursue arbitration at all. And that's by no means an exception. That is in fact very routine, especially when it comes to organization, because as you rightly said, a lot of their contracts are templators. So the general counsels in consultation with the top law firms typically have a standard form contract, which they just use across board in their organization, irrespective of whether the party that they're entering into contract is sophisticated or non-sophisticated, irrespective of the value of the underlying contract, etc. And that for me was a problem, which made arbitration less accessible. And I thought we need to start looking at changing that dispute resolution clause to make it more accessible.
Right. And when you say you want to make arbitration more accessible, uh, And I'm assuming that when it comes to SIAC or these international arbitration centers, the main cost factor is one, the arbitrator themselves, and second, the whole documentation processing aspect. So, what would that look like when it comes to cutting the cost for arbitration?
Sure. Excellent question, right? Uh, Even within the cost of arbitration, if I can just break that down a little bit, right? There is the institution's cost. There is the neutral, the arbitrator's cost. There is your legal fees, which is your lawyer's costs. And then the point you talked about, which is the sort of documentation, the effort cost that goes with the entire organization playing a role in that dispute resolution process. When we're looking at reducing costs, I'm looking at reducing costs across all four of those parameters. A, we are looking at dispute resolution clauses which provide parties an option to choose institutions, because for me, institutional arbitration is the way to go. Ad hoc arbitration, the way it's been done so far, is absolutely terrible. But that's a conversation for an entirely different podcast. But institutional arbitration, but accessible institutions which have a more reasonable fee structure for low value things. Number two, arbitrators. Again, depending on the seniority of the arbitrator, you pay a different value. A lot of times, institutions have fairly fixed bands. I mean, they appoint more senior arbitrators for more complicated and high value disputes and more junior people for low value disputes. But typically, the institution has a published range, which is a standard range which varies with the value of the dispute, but it is relatively fixed. It's not looking at the complexity of the dispute itself. That can be changed by choosing institutions which allow for more junior arbitrators to be part of this decision-making process, especially for smaller value claims. The third is legal fees, and the legal fees is inherently tied to the time taken to dispute resolution. So the longer the time, the more the legal costs are going to be. The shorter the time, typically the legal fees are. So the ability to choose institutions which reduce the time for dispute resolution. And fourthly is the effort of the parties to be part of this process. And there is the effort cost of the management participating in the dispute. And also there is an actual logistical cost of things like traveling to dispute resolution hearings, couriering documents in hard copy, printing them in 10 different volumes and making multiple copies, etc., etc. There again, we want to reduce those costs. And the way we're looking at doing that is to provide them an option where, say, an institution is administering the dispute at a lower cost with more junior arbitrators for simpler disputes, which allows parties the ability to conduct proceedings without necessarily having to travel or file documents in hard copy. And for me, that solution was ODR, or online dispute resolution. At core, that's sort of embedded in our DNA. We have a different fee structure for different values of claims, particularly for low value claims. We have a very low cost structure, which comes in at about 5-10% of the cost of typical traditional arbitration institutions. I'm not saying 5 to 10% off. It is literally 10% of the entire cost that they're going to be spending on that, both at an institutional level and the arbitrator level. All of our proceedings are conducted in a really time-bound fashion. So typically 3 to 6 months. That makes legal fees tend to be much lower. And fourth is, because it's an online dispute resolution platform, you are able to conduct proceedings entirely virtually. Your filing is entirely digital. So there is no spend on logistics like printing and couriering, etc., which of course is great for the environment, but also light on the pocket for the parties. So that is an option that I wanted to present to the parties in their dispute resolution clause, while still recognizing that there may be certain categories of disputes, especially the super complex high value disputes, where the parties may not want to go for this 3 months to 6 months resolution time period with relatively junior arbitrators. And that for me was a challenge which we could address with some creative drafting.
Okay. So, how does this provision look like in the contract when you have to have multiple layers of process, one for a certain type of dispute, if the contract is going to talk about court being one of the dispute resolution partners, and then for a more high value complex situation. So, how do you incorporate this in contracts usually?
Right. So it is about identifying where and what kind of disputes you want an ODR kind of offering like court, and in what or which kind of disputes would you want a more sophisticated, established ODR, ADR institution like, say, an MCI or an ICC or an SIC, right? And that boils down to factly two factors: value and complexity. So if you are able to draft your clause, and typically what happens is, even where there is some degree of complexity is involved, but the value is very low, uh, you can't afford a more, or it makes no sense to go for a more sophisticated arbitration institution. So even within those parameters, more often than not, it's really the value that becomes the driver of which of these institutions to choose. So the clause that we recommend parties to adopt, and that's sort of my big idea here, is identify a threshold in your contract to say, let me take 5 crore as an example. Any dispute which is 5 crore and above goes to your more sophisticated, it could be an MCI, ICC, SIC arbitration. So you run it like a normal institutional arbitration does, the way you've experienced it so far. But anything below 5 crore will go to online dispute resolution. So you put that monitoring threshold. And to make it certain, because of course, the experienced arbitration practitioners might be listening and might be wondering, oh, what if there is a claim which is of 4 crores? What if there's a counterclaim which exceeds it? Things like that. Again, capable of being taken care of in drafting, where you say, this is the threshold which is fixed at the stage of filing your claim. And above that, everything goes. Doesn't matter what the value of the counterclaim is, doesn't matter what the value of the revision of the claims is during the course of the arbitration. It's possible to do. And that is where some specific drafting can help. But that really is the idea. Single clause, which has the option of a more complex institution, the option of an ODR institution, which frankly is capable of handling complex cases, but it's still to establish its credibility to do that. So until then, give the smaller disputes to them, but have that option for the party. So instead of writing off those sort of contracts and debts, you can have a viable option for you.
And I think I'm also curious that is it possible for us to also put in a mechanism saying that when it's a mere breach of contract, question of fact versus a question of law, that maybe the parties think needs, like you said, not a junior level arbitrator, but a more sophisticated person. That was one part of the question. And the second part is also that why is this, or is this awareness not present among lawyers, law firms, general counsels? Because ODI platforms have been around for a while now. And why is this not being more proactively used?
Right. Okay, let me take those questions in turn, right? For the first one, when you're talking about simple disputes versus complex disputes, it becomes super difficult to try and identify them at the stage of contract drafting itself, because you really don't know what is a simple or a complex dispute. If you know and you expect, let's say, for instance, you have let me take the example of shareholder disputes, just because you talked about them earlier. And if you know there are certain kinds of disputes which typically tend to be simple, then you can put them and say that if there is anything to do with exit rights or exercise of exit rights, which I'm not saying are simple, but they have a more limited set of issues, then you can say they go to ODR. But let's say
like oppression mismanagement.
when suppression mismanagement, you probably go to the NCLT. But what you're right to say, but say something on the lines of breach of indemnities and warranties, where there might need to be a far more detailed, granular, factual analysis. You might say, I will push it out to a more complex dispute resolution institution. I mean, there again, as I say, I know that there are companies in which actually an exit right is a complex dispute because it involves questions of valuation of the company, the future cash flow, etc. So while in theory you can do it, I think in practice people would struggle. And I don't necessarily think it's worth doing that gymnastic exercise at that stage itself, although logically it makes sense. Which is why I said between value and complexity, value is more objective. It's easier. There is going to be lesser of a fight about whether it's this or that. So I would lean in favor of making that tiered approach based on value. Okay, let me try and address those questions in turn, right? The first question was on whether we make the tiered mechanism based on complexity. I have some reservations for that because I think it's a very difficult exercise to undertake. Because when you're drafting the contract, it's almost impossible for you to identify with precision exactly what kind of disputes are simple, what kind of disputes are complicated. For instance, if you say take construction, because those are the most common kind of arbitrations that are encountered. On the one hand, you might say anything related to payment delays is a simple dispute because it's simply a question of when was the invoice raised, when was the payment made, which may lend itself to ODR. On the other hand, say something to do with variations or time and cost extensions are complicated, so let it go to a more sophisticated institution. But the problem is that it's impossible to bifurcate the two because the defense to one might be the other. So that, for me, therefore, is a very difficult exercise to undertake because it needs a lot of gymnastics to be done. On the other hand, value is a far more objective, relatively easy to ascertain kind of an issue. Even there are complications, mind you. For instance, if I'm asking for a simple injunction, how do you value that? Right? But those are capable of being asserted. For instance, under the court rules, we say even when you ask for a non-monetary relief, provide a basic quantification so that we can fix the fees, etc. So there are proxies that you can adopt for it. That is more easier. So for me, therefore, when you're drafting a clause, instead of trying to think of all of these, because it's impossible, make it a lot simple. Basis of value, whatever that value is, make the clear structure. On the second point, if it's so wonderful and intuitive, why are people not doing it so fast? You're right to say ODR has been around for a while, but I think people have still viewed it with a little bit of circumspection because in the larger scheme of dispute resolution, ODR, which in India is about 5-6 years old, is still very new and nascent, right? So they needed some degree of credibility to be established before they can start making that trust. And I think we are there now. We're looking at regulators like SEBI adopting ODR as a default mechanism, the Niti Aayog making that recommendation in its ODR policy. So the businesses are starting to see that benefit. So I think now is a good time to say, look at them even for your contractual disputes. And that, therefore, leads itself to the question of how to take it forward from here. Going to the point on credibility, going to the point on them that they've proven their worth so far. Now is when we need to go tell the GCs, hey, there is this option, there is this mechanism that is available. Look at it, consider it. The reason people have not done it internationally is also, I think, a factor of in simpler disputes, typically courts have been good enough. So they may not have had the resort for simple disputes to be sent to arbitration. The need for arbitration for literally the entire gamut of cases is in some senses not an India only problem, but certainly aggravating in the Indian context. And there has not been an alternative so far. So now that there are alternatives, it's worth that the general counsels explore it. And in my conversations, there's been great reception to it. So I have gone and pitched this idea to GCs of very large Indian companies, and they've intuitively said, this makes sense. I have been writing off these debts. I no longer need to do it. And even if I'm no better off, so long as I'm not any worse off, I will try and adopt it and run forward with it. So I think that shift in mindset comes with a little bit more of awareness building, which is what we need to do now.
Yeah. And my final question is in this whole suite of, okay, there's sports, there's arbitration, a little more sophisticated arbitration, and then there is more accessible arbitration like ODR. Where does mediation as a concept sit within this? And would you recommend that be put in clause as mandatory resolution? Because one thing that I think the Commercial Courts acted was to mandate mediation before going into the courts, but that's barely seen positive results. I think about 90 to 95% of the mandatory mediation matters get stuck for non-starter cases. That is, parties are not even willing to mediate in the first place. So where do you think that would sit?
Again, another excellent question. I think it fits with the philosophy of mediation the way India is trying to promote it, right? There are, first, no easy answers, but the short answer is I think mediation has a very important role to play even in this structure, but I think with some guardrails. What are the problems with mediation? Today, the way mediation is being advocated is still very ad hoc. Even in the commercial courts context, there is, for instance, in each city, there is a panel of mediators, etc. But the mediators themselves are not being proactive. It's more seen as a rubber stamp exercise, right? Because the court sent the notice, is it responded to, not responded to, etc. So we need to address that. Can mediation actually be used as a tool to educate parties to try and not compel them, but at least encourage them to participate in the process, which is not happening now. Number two, in the course of the mediation also, the fact that it is taking so long to do mediation, particularly in the court context, and even in an ad hoc arbitration context, unless you specify the outer limit, mediation can go on for months on it, which parties find frustrating because that is stopping them from getting an ultimate resolution. If
This is the not on the parties, the delaying, the prolonging it. Because I'm assuming when there's a dispute, parties really don't want to come together.
No, so I think the delay can happen on both ends, right? The parties may delay the process, but the mediator may also encourage them to say, okay, let me try and explore a settlement, even if it takes a little longer, right? So they could be in any number of those things. And without some sort of outer boundaries, it can become an endless long process before you go to formal dispute resolution. So I think that's the second thing that you need to address. Both of which I think you can address with a well-drafted clause. Number one, if you put mediation into your clause, please ensure that there is an institution administering the mediation because it comes with it a few benefits. One, they will have a panel of mediators so they can actually recommend names and appoint things. Don't leave it to the consent of the parties because once there is a dispute, parties are never going to consent to the mediator. Number two, the institution is going to ensure that the mediators who are appointed are well trained, well educated, so they know how to run the process in a more professional manner, because that really is very important. Mediation is a skill. It's not an art. A lot of people try and think that I'm inherently a good mediator. No, there's actually a lot of skill that you can learn. And institutions do a good job of identifying those people, training them, and putting them. So you reap the benefits of mediation if you have an institution doing that process. Once you have an institution appointed, the second thing you would want to do is to set outer limits. You don't want mediation becoming an expensive process. You don't want mediation becoming a dragging along process, right? So you say 15 days, 21 days, 30 days, whatever is comfortable for you. You say we will attempt mediation for X number of days. If there is no resolution, automatically I have the ability to initiate a formal dispute resolution, which means people start taking those 15 days more seriously, whether parties attend, not attend, etc. In that, even in that process of 15 days also with a professional mediator, what they are able to do is they will reach out to the parties proactively, especially if an institution is involved, which means you are educating them, right? I can give you an example of how we do it at court. When there is a mediation that comes to us, we call each of the parties separately and we tell them, listen, we've been approached by the other party or you approached us, either way, or the contract provides for it. This is mediation. We are not forcing you. It's a time-bound process. We encourage you to do it because whatever you say, A is not admissible in a future course of arbitration. It is entirely voluntary. So unless you agree, there's not going to be a settlement. So you educate them and ensure that they come, because otherwise a lot of people are under the misconception that the minute they come to mediation, they're committing themselves to something that someone else might decide for them. All of those myths you can break with those approaches, which institutions do that. Once that is there, you suddenly have a greater resolution rate, more success percentages. Our experience is that where there is mediation which is done in this fashion, it is actually not a rubber stamp exercise and parties actually settle. And for businesses, even if they take a haircut, it is much better than going through the entire arbitral process, thereafter a challenge, thereafter an enforcement. So it makes business commercial sense. But only if these guardrails are there. Institutional mediation sets timelines, because otherwise, I mean, it's free flow.
Okay. Okay, great. So I think the two main takeaways is the role that lawyers can do in making the process more accessible for litigants across the board. And second, how important it is to institutionalize these processes of both mediation and arbitration. Thanks, Vikas. This is very interesting.
My pleasure. Thank you for having me.